Do I have time for a question, Mr. Conacher?
Sure.
Just about your testimony to the Informal Committee on Foreign Affairs. Do you mind asking a quick question about that?
No.
I was reading a live blog about it from Katie O'Malley, so
Yes.
just want to confirm. You were saying that you hoped it went to the Supreme Court if they still refused
Yes.
the documents?
Yeah.
Can you just give me like your reasoning for that, why you think it's necessary?
Well, you have the Parliamentary Council, the MP's lawyer, essentially advising opposition party MPs in this case, because the ruling party MPs have lined up with their cabinet and their leader. But the opposition party have asked the House of Commons lawyer for an opinion, and he says, well, they have a right to see these documents, maybe in camera, behind closed doors, and only the committee members, and maybe they will have to take some sort of oath of non-disclosure, but at least that, and that a parliamentary committee can see the documents. The government lawyer is saying Parliament can request these documents, but can't, again, see them entirely. The government still has a right to withhold certain things under the various acts, the Information Security Act, the Canada Evidence Act, the National Defence Act, as well as the General Access to Information Act. So, you can either go the route of finding the cabinet ministers who are involved in refusing to disclose the documents in contempt of Parliament, which in a minority parliament the opposition parties could easily do, because they're a majority of MPs. They could pass that resolution. They could penalize those ministers. But that doesn't resolve the issue of whether Parliament actually has these rights. And you just have the government lawyer saying, no, we don't believe that these cases that the Supreme Court's ruled on in the past make this clear with these kind of documents. So how do you resolve it? Well, you refer it to the Supreme Court. And there's two ways to do that. The government can do it. The cabinet can refer the whole issue for a ruling. Essentially, they would take one of the information requests and say, did the Supreme Court of Canada rule on this request? Or the opposition parties could do a little sort of roundabout way, which is they would introduce a private member's bill to change all of these acts in a way that would give Parliament a clear right to see any document at any time in full. Maybe with some conditions like behind closed doors, with parliamentarians swearing an oath of secrecy. And then the House of Commons can actually refer a private member bill to the Supreme Court for a ruling as well as to whether it's constitutional or whether it's needed. And those two routes are open. And then you've got a resolution of this issue, which I think is going to come up again and again in the future.
Would the resolution be just a determination of what the government can refuse on national security grounds, or would it be a wider scope?
The government can send several questions to the Supreme Court of Canada, and these changes, if the opposition parties decided to do it, if Cabinet refused to do it and they decided to introduce a private member bill, then they just put in amendments that would raise all of those questions. And essentially the question they'd be sending to the Supreme Court of Canada is, do we need to amend these bills in these ways, and these laws in these ways, in order to give Parliament the right to see these documents? And the Supreme Court would essentially then rule, no you don't, because you already have that right under the constitutional conventions, the Constitution, the Parliament of Canada Act, and all the provisions in those laws. Or they would rule, no you don't have to, and these amendments are actually needed. And then if they were needed, well then the parties would pass those, presumably pass those private member bill, changing all those laws, and we'd resolve the issue forever.
Do you think this is more a matter of, or I'm sure it's both in a way, but what do you think is the priority, the parliamentary process here, or do you think it's still a matter of international human rights, or however the opposition parties frame it? Do you think that's still relevant?
Well, you need the documents to know who knew what when, and that's key to determining, from my understanding, and I was testifying with an expert in the area, you need that evidence to know whether there's any cause at all to pursue something through the International War Crimes Tribunal processes.
Mr.
Craig Scott.
Was there Mendez who was testifying?
He testified the week before, but they've all essentially said the same thing, and Craig Scott is a professor at Osgoode Hall Law School at York University, and they had held a big forum a couple of days before we testified and had various experts come forward. And some people think there's enough evidence there already, but what is not known, a lot of what's been cut from these documents, is who they were sent to.
Yeah.
And that's key to knowing who you charge.
So it could be Peter McKay or
Yeah,
someone.
and that's, you have to know who they were sent to, and that's part of what's being withheld. There's also some other key information in there. What were they actually told? And that's key as well, because they have to have full knowledge. From my understanding, the line is knowledge that there's a likelihood that there would be torture if someone was transferred. So what they knew and who knew it obviously is key in terms of pursuing that. So it's dual, but what we're focused on is this right of the Parliament to see government documents. That's an ongoing issue. That's going to come up again and again. The one case that the MPs, the House of Commons lawyer, has cited is a case that involved the Speaker of the House of Commons and how he was treating a particular staff person. And it's not the same type of document at all.
Yeah.
And so just citing that case and say, well, the Supreme Court said Parliament can see these, well, those type of documents, but see a document that's covered under the National Defence Act and the Information Security Act and the Canada Evidence Act within this context, that's a different case entirely.
I should break in.
Yeah,
John probably needs to get going.
But there's just, see, I would disagree with that. I think that, not on the Afghanistan stuff, that's different, but there's two things here that are key. One is, no parliament can bind another parliament. So in other words, you can pass all the acts you want, you cannot bind a future parliament, except through a constitution. Okay. The other thing here is that Parliament is supreme. Again, that's an inherent notion of our system, is that Parliament is supreme. So to go to the courts to ask that question, essentially you're asking them to say, is Parliament supreme? Can we do this? Is, in my mind, in a sense, doubting that you can or not. I mean, you can do what you think. So there are remedies. Parliament does have remedies if they refuse, and so Parliament should follow through with those remedies. Okay, so if the minister doesn't, they expel the minister from. There's one that's conservative. Another minister, he's advised, he doesn't do it. They expel that minister.
Just take.
Yeah, just carry. I mean, essentially, you're using the tools and you're proving that Parliament is what it is. You're not going to the courts and saying, "Are we what we think we are?" You're saying we are, and these are the tools that we have to demonstrate that we are.
Is that just a simple majority vote?
It's a simple majority vote.
Yeah. The problem with that is, first of all, I'm not saying you're going to the Supreme Court to say, does Parliament have this or not? It is to say, based on all of the conventions and the cases from the past, this is clear. Well, you're just getting essentially as a referral. And the reason you need that is 3 opposition parties throwing out a ruling party minister. Well, how do you think the public's going to view that? Well, no kidding, because NDP, Liberal, and Bloc members found a Conservative minister guilty. Really, no kidding. Like, it's not going to. It is a kangaroo court. It's like saying. It's like selecting your own political tribunal and then condemning your political rival. That's not going to have a lot of legitimacy in a lot of people's eyes, including, I think, a lot of Liberal, Bloc, and NDP members. And the parliamentary committees have shown it in the last, through these minority parliaments that we've had since 2004, is they have shown that when they investigate purely along partisan lines. You may have 1 or 2 of the members stick and show a lot of integrity and be fair, but you have a lot of blanket statements made about people, conclusions stated, that are based totally on the fact that you're from one party and the person testifying is from another. You saw that with the Mulroney-Schreiber hearings, and you've seen it in a few other cases, and that doesn't resolve anything. So the courts have been appointed, the Supreme Court has been appointed by both Liberal and Conservative prime ministers, and with committees set up to ensure they were qualified, etc. So you just have them settle the question before proceeding with a highly partisan process that's not going to settle anything, and you're not going to get the documents either. Well, you throw them out; they just can refuse. You're going to throw out the whole cabinet.
you think there's still some political urgency from, say, the Liberals and NDP to get some kind of resolution now before, who knows what could happen in the next couple of months? Because I assume the time span's a couple of years in the Supreme Court.
For a referral case, no. Shouldn't be. The opinions are
It'd be
written.
at least 6 months.
Yeah, but the opinions are written. The House of Commons lawyer has written his argument of law and fact, and so has the government lawyer. So it can be a very quick process. And the Supreme Court, I'm sure, would recognize the urgency of clearing this up.
We really should wrap it up.
So-
Yeah,
I've got a
okay.
couple other
Sorry.
places.
Yeah.
Hey guys, thanks for